Usually when we talk about the rule of law in a modern democracy, there is this fundamental expectation of structural integrity.
Right, absolutely.
Like I always picture it like a massive suspension bridge. You drive across that bridge and the laws of physics, well, they apply equally to everyone. Gravity really doesn't care if you're in some beat-up commuter car or like a $500,000 luxury SUV.
Yeah, the bridge holds you exactly the same way.
Exactly.
I mean, it is the great equalizer. The foundational premise of any republic is that the rules governing the structure are blind to the status of the people using it.
Right.
Because without that universal constant, the entire engineering of the state just starts to buckle.
But today, we are looking at a system where that bridge seems to be operating with two completely different sets of physics. So welcome to another deep dive.
Glad to be here for this one.
We are going to examine the French political and judicial landscape today. And, before we go any further, I really want to stress something to you, the listener. We aren't dealing in rumors here.
No, not at all.
No partisan spin, no political theory today. Everything we are about to explore is pulled directly from verifiable legal proceedings, official parliamentary inquiries, police records, and documented financial data.
Which, honestly, is the only way to examine a subject this sensitive.
Yeah.
We are looking at a chronological timeline of events that reveals a fascinating and, well, frankly, concerning architectural shift in how power is exercised.
Right, we're going to trace a line, really, from the boardroom sell-offs of strategic national assets.
Straight down to how police custody is utilized on the streets of Paris.
Yeah. And finally, all the way up to the special courts that judge the highest ministers in the land.
It's a huge scope.
It is. So I want you to keep that contrast in your mind as we go. Just imagine a system with two completely different rule books. One applied with immediate physical force on the streets, and another like an incredibly flexible rule book operating inside the Élysée Palace.
Yeah, but to understand how a justice system flexes around power, we first have to understand how that power is consolidated financially in the first place.
Right, the money.
You can't understand the street protests without understanding the boardrooms. So let's rewind to 2014 and look at the sale of Alstom's strategic energy division.
And I realized when I was looking through the parliamentary notes on this, I only vaguely knew what Alstom actually was. I knew they made trains, right? Like the TGV.
Well, yeah, they do make trains, but that's the transport division. The division we are focusing on is Alstom Power. And to call it a crown jewel of French industry is, honestly, almost an understatement.
Oh, really?
Yeah, you have to look at the history of France's energy grid. So, decades ago, under Charles de Gaulle, France made this massive multi-generational commitment to nuclear energy.
Right, to ensure total national independence.
Exactly. They didn't want to rely on foreign oil or gas.
Yeah, they have, 56 nuclear reactors powering the country? It's like one of the most nuclear-dependent grids in the world.
It is. And Alstom Power manufactured the turbines for those reactors, specifically the Arabelle turbine, which is, it's an absolute marvel of engineering.
Okay.
It's massive, it's incredibly efficient, and it's vital to the functioning of the French state. But it goes beyond just keeping the lights on in Paris.
Wait, what else did they make?
Alstom Power also manufactured the propulsion turbines for the French military's nuclear submarines.
Oh, wow.
Yeah, as well as the Charles de Gaulle aircraft carrier.
So we are talking about the absolute core of French national independence here. You don't have an independent nuclear deterrent if you literally don't control the company making the engines for your nuclear submarines.
Precisely. It is the textbook definition of a strategic national asset. And yet, in 2014, this massive, vital entity was sold to an American corporate giant, General Electric.
For roughly 12 billion euros, right?
Oh, yeah, around that.
It's like quietly selling the engine of your car to a rival and then having to lease it back just to drive to work.
That's a great way to put it.
But the mechanics of how this deal was brokered, they are staggering when you actually look at the paper trail, especially the internal bureaucratic warfare.
Oh, the internal warfare is key. The players involved are essential to understand here. So at the time this deal was quietly being formed, Emmanuel Macron was not yet the president.
Right. He was what, an advisor?
He was the Deputy Secretary General at the Élysée, working as a senior advisor under then-President François Hollande.
Okay.
Now, the sitting economy minister at the time, the person whose actual job it was to oversee French industry, was Arnaud Montebourg.
Right. And Montebourg was famously, almost aggressively protective of French industry.
Very much so.
He was the guy wearing the Made in France striped shirts on magazine covers. He was fundamentally opposed to selling off strategic assets to foreign powers, particularly American conglomerates.
Yeah, from the notes, it seems he actually preferred a different European-based deal with the German company Siemens.
He wanted to keep a European footprint, yeah. But according to the findings of a subsequent parliamentary inquiry,
The one led by Olivier Marlex.
yes, exactly, a massive investigation led by Deputy Olivier Marlex, it found that Emmanuel Macron essentially maneuvered entirely behind the sitting economy minister's back.
Yeah, the bureaucracy of it is wild.
I was reading about this maneuver, and I couldn't quite figure out the bureaucratic plumbing of it. So in October 2012, while Macron was at the Élysée, a study is secretly ordered from an American consulting firm, A.T. Kearney. It cost €200,000, was marked secret, and it was explicitly looking into the advantages of changing the shareholder structure of Alstom. But the controversy is really about who ordered it, right?
Yes, and to understand why that matters, we have to look at how French bureaucracy is actually structured. Normally, if the state wants to study the industrial strategy of a vital company, that request goes through the Directorate General for Enterprise, the DGE.
Okay, the DGE.
Right, and the DGE reports directly to the Ministry of the Economy, in this case, Arnaud Montebourg.
Ah. So if it goes through the DGE, Montebourg sees it, he knows about it, and he likely kills it if it involves selling to the Americans.
Exactly, he would have stopped it dead. So the DGE was bypassed entirely. Instead, the study was ordered by the State Participations Agency, the APE.
Which does what exactly?
The APE manages the state's corporate holdings. At the time, it was headed by David Azima, who was known to be very, very close to Macron.
But wait, Olivier Marle's parliamentary inquiry pointed out a massive incongruity here. The French state wasn't even the primary shareholder of Alstom at that time.
No, they weren't.
The conglomerate Booz was the main shareholder.
Which makes the APE's involvement highly irregular. I mean, the state holdings agency spent $200,000 of public money on a secret study for a company they didn't even hold majority stake in.
Wow.
And they bypassed the economy minister completely to do it. The parliamentary inquiry strongly indicated that the Élysée, specifically the Deputy Secretary General's office, was laying the covert groundwork for the sale to General Electric long before it became public knowledge.
Deliberately circumventing the minister in charge?
Yeah.
And then, the political dominoes fall. Montebourg is ousted from the government in August 2014 after criticizing the government's economic line, and who immediately replaces him as Minister of the Economy.
Emmanuel Macron.
Right, Emmanuel Macron, the guy who was allegedly laying the groundwork for the deal, steps into the exact ministerial role required to approve it.
And this is where the legal mechanism of the sale becomes really fascinating. To finalize a deal like this one, involving a foreign takeover of a strategic defense and energy asset, you need a very specific authorization.
Right.
Macron utilizes a piece of legislation known as Article L151(3) of the Monetary and Financial Code.
Let's define that code for a second so we're clear. What exactly does L151(3) grant the minister the power to do?
It is a profound concentration of administrative power. Article L151(3) basically gives the Minister of the Economy the unilateral authority to authorize, subject to conditions, or outright block foreign investments in sectors deemed critical to national interests.
So things like public order, public security, or national defense.
Exactly. And energy infrastructure and submarine propulsion obviously fall squarely into that category. The minister holds the pen.
And Macron used that pen to sign the authorization.
He did, effectively handing the manufacturing of France's nuclear and military turbines over to an American corporation.
So he allegedly orchestrates it from the shadows at the Élysée using the APE, then steps into the spotlight as economy minister and signs the paperwork using L151(3).
Yep, that's the timeline.
But let's look at the financial ecosystem surrounding this, because this is where the parliamentary investigators and anti-corruption groups really started raising alarms. I mean, a €12 billion transaction doesn't just happen between two CEOs shaking hands over lunch.
Oh, far from it. Mergers and acquisitions of that scale require a massive army of intermediaries. You're talking investment banks, strategic consulting firms, corporate law firms, auditors.
And they do not work for a flat hourly rate.
No, they do not. In high finance, they operate on what are called success fees.
Which means they only get the massive payout if the deal actually closes.
Right.
And the deal only closes if the Minister of the Economy, in this case Macron, signs the authorization, allowing it to go through.
Precisely. And this transaction generated a staggering amount in intermediary fees. The officially documented figure is 265 million euros, paid out by Alstom to banks and advisors.
Okay, just to put that in perspective for a second.
Yeah.
265 million euros. What work are they actually doing to justify €250 million in fees?
Well, it covers everything from finding the buyer, structuring the debt, conducting, thousands of hours of due diligence to managing the regulatory filings across multiple jurisdictions.
Okay.
But the key is that the fee is a percentage of the total deal value. So when a deal hits 12 billion, the fees become astronomical.
Right.
And one of the primary beneficiaries of those massive fees in the Alstom deal was the investment bank Rothschild & Co.
Which is Emmanuel Macron's former employer. He was a highly successful investment banker there before he joined the government, right?
Right.
Earning millions himself, brokering major corporate deals.
Yes, his ties to Rothschild are very well documented. So Rothschild & Co., along with several other institutions, pockets this massive success fee because the Minister of the Economy authorized the sale.
Right.
Now, if the story ended there, it might just be viewed as, I don't know, a controversial industrial policy decision. But the loop doesn't close there.
No, it doesn't.
Fast forward a couple years to 2016 and 2017. Emmanuel Macron leaves the government, launches his own brand new political movement, En Marche, and runs for president of the Republic.
And running a presidential campaign as an independent without the backing of a traditional decades-old party structure like the Socialists or the Republicans, that requires a massive immediate influx of cash.
Oh, absolutely.
I mean, you need to rent headquarters, hire staff across the country, run rallies, print millions of flyers.
It requires an unprecedented fundraising effort in a very short window of time. And this is where the data becomes incredibly illuminating.
Okay, let's get into the data.
Following the Macron leaks, which was that massive dump of internal campaign emails and documents right before the 2017 election, researchers, investigative journalists, and parliamentary investigators like Olivier Marleix started doing something very basic.
What's that?
They started cross-referencing the lists of major campaign donors with the people and institutions involved in the Alstom sale.
Oh, wow. And what did they find in that cross-reference?
A very distinct pattern emerged regarding maximum limit donors. So in France, campaign finance laws are quite strict compared to, say, the United States.
Right. Corporations can't donate, right?
Exactly. A corporation cannot donate to a political candidate. Only individuals can. And the legal limit for an individual to donate directly to a political campaign is $4,500 desire. Additionally, they can give $7,500 to the political party itself.
Okay, so if you are a wealthy investment banker, you can give €12,000 total. And if you are married, your household can basically inject €24,000 into the political machine.
Exactly. And what the records showed is that several individual beneficiaries of those massive 265 million intermediary fees from the Alstom deal, including former and current partners at Rothschild & Co. and executives at the consulting firms involved, suddenly appeared as these max donors for En Marche.
And they weren't just passively writing checks either, right? According to the inquiry, they were actively bundling.
Yes, bundling is the key mechanism here. Since an individual can only give so much, the real value of a wealthy supporter is their network.
Right.
These individuals from the financial sector were actively organizing elite private fundraising dinners in London, Paris, and Geneva. They were gathering their colleagues, their clients, and their partners, ensuring that dozens of people in a single room were all writing those maximum legal checks to fund Macron's 2017 presidential run.
So if I'm looking at this from the perspective of an anti-corruption group, and several of them, like Anticor, formally flagged this to the justice system, what exactly is the legal accusation? Because, I mean, bankers donating to pro-business politicians happens in literally every democracy on Earth. It's practically the definition of high-level politics.
It's a critical distinction to make, and it requires understanding a specific offense in the French Penal Code called prise illégale d'intérêt, or the unlawful taking of interest.
Unlawful taking of interest.
It is one of the most complex infractions to prosecute, honestly. But essentially, it applies when a public official takes, receives, or keeps an interest in a business or an operation over which they had a supervisory, administrative, or decision-making role.
Got it.
And crucially, it applies if that interest compromises their independence or objectivity.
So the argument presented to the prosecutors is that Macron's signature as economy minister was the singular bottleneck. Like, his authorization allowed the Alstom deal to close, which triggered the $265 million in success fees to the bankers. And then shortly after, those specific bankers utilized their new windfall to finance the political rise of the very man who signed the paper.
That is exactly the mechanism Olivier Marlex asked the prosecutor's office to investigate. He formally filed what is known as an Article 40 report, asking the justice system to look into whether there was a pact of corruption.
A pact of corruption.
Because if the authorization to sell a strategic national asset, trading away sovereign independence over your nuclear grid and military propulsion, was functionally utilized as a mechanism to generate massive capital that was later recycled to fund a personal political ambition.
That is a profound structural breach of the rule of law.
Exactly. It changes everything.
And Alstom wasn't the only one. During his 2 years in the Ministry of the Economy, Bercy, we saw massive shifts. Alcatel, Lafarge, Technip, roughly 10% of the French CAC 40, which is their major stock market index, was sold off or merged with foreign entities.
Yeah, billions of euros moving.
Massive success fees generated for the financial sector, and then a brand new political party suddenly awash in max donations from that exact same sector.
But here is the critical point about the architecture of justice. Despite the exhaustive parliamentary inquiry, despite the formal Article 40 reports filed by elected deputies, and despite the detailed complaints drafted by anti-corruption NGOs.
What happened?
The justice system's response to these high-level financial maneuvers has been characterized by extreme lethargy. Investigations of this nature, if they are opened at all, disappear into the lap of the financial prosecutor's office.
Oh, of course.
They drag on for years, sometimes a decade, without resolution, buried in requests for documents and preliminary analyses.
The gears of justice grind incredibly slow when looking upward.
They really do.
But, when you sell off a country's industrial backbone, when you execute highly unpopular economic reforms that favor the financial elite over the working class, you inevitably create massive economic anxiety on the ground.
Inevitably, yeah.
And eventually, that anxiety turns into friction. It turns into mass protests.
And when the public pushes back, the state has to respond. If you are not going to change the economic policy, your only option is to manage the social friction.
Right.
And the primary tool a state has to manage social friction is the prosecution service, known in France as the parquet.
Which brings us to the second part of our timeline. Because instead of policy changes, we see a distinct shift in the legal physics of crowd control. Let's look at the Gilets jaunes, the Yellow Vest protests, and how the justice system was mobilized to handle them.
Yeah, this is where it gets really dark.
Specifically, we need to look at a pivotal figure, Remy Heitz.
To understand what happened on the streets of Paris in early 2019, you first have to look at a bureaucratic administrative decision made behind closed doors in November 2018.
Okay, November 2018.
The appointment of Remy Heitz as the Paris prosecutor.
Now, for anyone unfamiliar with the French legal system, the Paris prosecutor isn't just like a local district attorney. This is arguably the most powerful, highly scrutinized prosecutorial role in the entire country.
Absolutely. The Paris parquet oversees the most sensitive dossier in France. They handle major counterterrorism investigations, complex national financial crimes, public corruption cases involving politicians, and, crucially, the maintenance of public order in the capital.
Right.
The transition from the previous prosecutor, François Molin, to Remy Heitz was incredibly controversial.
Right, because François Molin was almost a national hero.
Oh.
I mean, he was the calm, measured face of the justice system during the horrific Bataclan terrorist attacks in 2015. He was highly respected by his peers for his fierce independence from political pressure.
So when it came time for Mullins to step down, the standard procedure is for the Minister of Justice to conduct a rigorous selection process. The High Council of the Judiciary reviews candidates and presents a meritocratic shortlist of the most qualified magistrates.
Makes sense.
But the executive branch, meaning President Macron's Élysée, allegedly intervened heavily in this process.
They didn't like the shortlist.
They bypassed the standard shortlist entirely. They wanted someone they could trust implicitly.
Wow.
They pushed to install Remy Heitz, who was not on the initial lists of top contenders for independence, but was instead working deep inside the Ministry of Justice as the Director of Criminal Affairs and Pardons. He was seen as an administrative loyalist, closely aligned with the executive's desires.
I was actually reading the reactions from the magistrate unions at the time, and they were furious.
Oh, they were livid.
The Syndicat de la Magistrature viewed it as a reprise en main, a political takeover of the prosecutor's office. They saw it as the Élysée, ensuring that a loyalist was holding the pen on the most sensitive cases, particularly regarding public order.
And almost immediately, that loyalty was put to the test, because right as Heitz takes office, the Gilets jaunes protests erupt.
The Yellow Vest.
Yes. These were massive, unprecedented organic demonstrations across France. Hundreds of thousands of people taking to the roundabouts and the streets, protesting stagnant wages, new fuel taxes, and a profound feeling of being left behind by the very elite we just talked about in the Alstom deal.
The protests were immense.
Yeah.
And yeah, to be entirely factual, they were sometimes very violent. There were burning barricades on the Champs-Élysées. The Arc de Triomphe was vandalized. Storefronts were smashed. The police were overwhelmed.
They were.
But it's how the newly appointed Paris prosecutor, Remy Heitz, decided to utilize the legal code to manage this crisis that brings us to the core of the weaponization issue. So on January 12, 2019, Heitz issued a confidential internal directive to all the magistrates operating under his authority.
And the text of this note is extraordinary when you view it through the lens of fundamental legal rights.
What does it say?
The memo explicitly instructed magistrates on how to process protesters who had been arrested by the police. It advised them to maintain these individuals in garde à vue, which translates to police custody, through the entire weekend, or at least until the Sunday morning.
Wait, I'm looking at the translation of this internal directive right now, and the justification he writes down is stunning. He writes that they should be held, quote, to prevent the interested parties from rejoining the ranks of the troublemakers.
Yep.
Is that even legal under French law? To hold someone just so they don't go back to a protest?
This is the crux of the scandal, and to understand why the magistrate unions revolted, we have to look at Article 62.2 of the French Code of Criminal Procedure.
Okay, Article 62.2.
Under this code, a garde à vue is strictly, exclusively an investigative tool. It is a severe deprivation of liberty that can only be legally utilized when there is, quote, plausible reason to suspect that a specific person has committed or attempted to commit a crime.
So it is designed to be reactive. Like, a bank is robbed, the police find someone running away with a bag of cash, they suspect him, so they hold him in a cell to interrogate him, prevent him from destroying evidence, or stop him from fleeing the country. It is for investigating a past action.
Exactly. But Heitz's note completely changed the physics of that legal bridge we were talking about. He perverted an investigative tool into an administrative tool for preventative crowd control.
Wow.
He explicitly instructed his magistrates to use the deprivation of liberty-locking citizens in cells, not to investigate a past crime, but to physically keep them off the streets to prevent a hypothetical future disruption.
It basically became a mechanism preventive to detention, pre-crime, locking people up just in case they might protest again on Sunday.
Yes. It explicitly bypassed the strict legal requirements of Article 62.2. And the directive went even further. It wasn't just about holding them in a cell for 48 hours to ruin their weekend. It was about creating a permanent administrative record of their dissent.
Right. The directive recommended that prosecutors prioritize entering these detained citizens into the TJ database. Explain what the TJ is, because honestly, this sounds like something out of a dystopian novel.
The TJ stands for Traitement d'antécédents judiciaires. It is a massive, centralized police background database shared by the National Police, the Gendarmerie, and customs officials. It contains records of individuals implicated in police investigations.
Okay.
Now, normally, if you are cleared of wrongdoing, you shouldn't be stigmatized in police files. But Heitz instructed that these protesters should be entered into the TJ database even if the infractions against them were not fully characterized, or if the case was ultimately dismissed and dropped entirely by the prosecutor.
So let me walk through this scenario to make sure I understand the gravity of it. You're a citizen. You go to a protest on a Saturday afternoon because you are angry about the cost of living.
Yeah.
The police do a mass sweep of the square. They grab you. They have zero evidence you threw a rock, smashed a window, or did anything illegal.
Yeah.
But based on this directive, they lock you in a holding cell for 48 hours just to keep you off the avenue. Then on Monday morning, they release you. No trial, no charges, completely innocent in the eyes of the law.
That's the scenario.
But now, your name and biometric data are permanently stamped into a massive police database as a suspected troublemaker.
Which has devastating real-world consequences. In modern France, being listed in the TJ database isn't just some invisible mark. That database is routinely checked for employment background screenings, particularly if you want to work in the public sector, in private security, in airports, or any job requiring a security clearance.
It's a punitive administrative mark applied without a trial, without a defense attorney having a chance to argue for you, and without a conviction from a judge.
Precisely. It is extrajudicial punishment disguised as bureaucratic procedure. And we really need to look at the actual human scale of this policy because the statistics gathered during this period show the immense scope of the dragnet.
Yeah, a collective of defense lawyers called Stop GAV formed specifically to track this abuse. GAV being short for Guard of View, they started compiling the data, and eventually the prefecture of police itself had to confirm the numbers.
And the disproportion is staggering. During one specific period of tension over just 3 evenings of protests, the authorities documented 425 people placed in preventive police custody in Paris.
425.
Out of those 425 people deprived of their liberty, only 52 cases resulted in any kind of prosecution.
That means over 80% of the people thrown into cells were completely dismissed. Over 370 people locked up for the weekend, completely innocent, just to clear the streets. It's fishing with dynamite. You just blow up the whole pond to catch a few fish.
It really is.
Let's talk about what actually happened to these people inside those cells, because the sources provide some visceral, chilling details. This wasn't just sitting in a waiting room reading magazines.
No, the conditions of a Garde à Vue in Paris can be degrading, particularly when the system is intentionally overloaded by mass arrests. We have the documented account of Elias, a 28-year-old neuroscientist.
Right.
He wasn't even in the black bloc. He was just in the area near Place de la Concorde when the police kettled the crowd. He noted that a jogger, literally in athletic running gear, was swept up right next to him.
Unbelievable. Elias is taken to a police station, held for hours, and forced to strip down to his underwear for a full-body search. He has a medical condition requiring specific eye drops. He asks to see a doctor. He is denied access to medical care for hours.
Yeah.
Eventually, he is shuttled across Paris in handcuffs in the back of a police van to a hospital just to get a doctor's permission to use his own prescription medicine. Then he's thrown back into a cell.
Then there is the testimony of Etienne, a 20-year-old volunteer for civil security and a photography student. He went to the protest to document it with his camera. He gets swept up, processed, and thrown into a 5-square-meter holding cell with 4 other people.
5 square meters, that's tiny.
Tiny. There are only 2 mattresses on the floor. And he is held there for over 24 hours.
And Melina, a graphic design student, she spent 20 hours in a freezing, drafty cell that smelled overwhelmingly of excrement because the toilet was broken. For almost a full day, she was given nothing to eat or drink except 2 dry cookies and a small juice box.
It's awful.
And the crucial point here, the thing that ties it back to the prosecutor's directive, is that Elias, Etienne, and Melina were all released on Monday morning with absolutely 0 charges filed against them.
None. They were innocent citizens subjected to physical and psychological deprivation solely as a method of crowd control. But if you listen to the government at the time, this reality was entirely denied.
I want to examine the government's defense here. The Interior Minister of the time, Gerald Darmanin, and the Paris police prefect, Laurent Nunez, went on national television and flatly denied this was happening. Darmanin explicitly claimed, quote, "There are no preventive arrests in France." Their argument was essentially, look, these people were participating in an undeclared manifestation. They were part of a group when infractions were occurring. The police are just applying the law.
It is a rhetorical sleight of hand. They conflated the administrative failure to file protest paperwork with the commission of a criminal offense justifying detention. But the legal community saw right through it.
Did they?
Oh, absolutely. The magistrates themselves, the very people tasked with executing Heitz's orders, pushed back hard. The Syndicat de la Magistrature wrote open letters denouncing the instrumentalization of their profession by the executive.
And it wasn't just domestic unions complaining. The international human rights community sounded the alarm. The Defender of Rights in France, Claire Haydon, which is an independent constitutional authority, issued a formal, urgent alert about the disproportionate and abusive use of privative liberty measures against protesters.
The UN Special Rapporteur on the rights to freedom of peaceful assembly weighed in too, stating they were monitoring France closely and explicitly warning against the use of excessive force and arbitrary arrests to chill democratic participation.
That's huge.
And perhaps most significantly, the Commissioner for Human Rights of the Council of Europe issued a sharp rebuke.
What was the Council of Europe's specific legal argument against Darmanin's defense?
The commissioner explicitly stated that the failure of organizers to formally declare a protest to the authorities does not, in itself, legally justify an arbitrary deprivation of liberty or a penal sanction against an individual participant.
Right.
The right to peaceful protest is a fundamental human right inextricably connected to the freedom of expression. You cannot suspend a fundamental democratic right by weaponizing an administrative loophole about parade permits.
So if we look at the bridge we are analyzing, the physics applying to the public are incredibly harsh. If you are a photography student near a protest, the system activates instantly. You are stripped, thrown in a 5-square-meter cell, denied medicine, and branded in a police database, all without a shred of evidence that you committed a crime. The law is applied preventively, aggressively, and physically.
That is the reality for the streets. But what happens when the legal system is forced to turn its gaze to the very top of the executive branch?
Right.
How does the justice system behave when it has actual documented evidence of a crime committed by the inner circle? This brings us to the accountability gap and specifically the case of Alexis Kohler.
If you want to understand how power actually functions in modern France, you really have to look past the cabinet ministers and look at Alexis Kohler. He's the Secretary General of the Élysée. He is the president's chief of staff.
Yes.
But even that title doesn't quite capture it. The French press often refers to him as the twin or the shadow president.
He is arguably the most powerful, unelected official in the country. He handles every major economic dossier, manages political crises, and oversees the vast machinery of the state. His physical office is located directly adjacent to the president's. His proximity to absolute power is unmatched.
And according to the National Financial Prosecutors, he also has a massive, highly documented conflict of interest problem, a problem involving billions of euros and his own family.
The conflict centers around Kohler's family ties to the Apont family. The Aponts are the founders and owners of the Mediterranean Shipping Company, widely known as MSC.
And MSC isn't just a business. It is a global logistics behemoth. They run massive cruise ships, they operate one of the largest cargo container fleets on Earth, and crucially for this story, they are one of the biggest and most vital clients of the French shipyards, specifically the Chantier de l'Atlantique in Saint-Nazaire.
The Saint-Nazaire shipyards are an issue of intense national sovereignty for France. The government has spent decades trying to restructure them, save them from bankruptcy, and manage their ownership.
Right. MSC orders massive cruise liners from these yards, injecting billions into the local economy and keeping thousands of French workers employed. The relationship between MSC and the French state is constant, highly negotiated, and strategically vital.
And Alexis Kohler's mother is cousins with Raphael Apont, the co-founder of MSC. Which, fine, people have wealthy relatives, you can't choose your cousins. But the timeline of Alexis Kohler's career is what triggered the anti-corruption NGOs. Let's walk through his professional timeline because it paints a startling picture of a revolving door.
It really does. So, from 2012 to 2014, Alexis Kohler worked as a senior official for the APE, the same French state holdings agency we discussed earlier in the Alstom deal.
Okay.
In that role, he was directly dealing with state matters, industrial policies, and contracts that affected the shipbuilding industry, and by extension, MSC.
Then, from 2014 to 2016, he moves up. He becomes the deputy chief of staff to the finance minister, who at the time was Emmanuel Macron. Again, Kohler is at the very center of French industrial policy, dealing with the shipyards and the maritime economy. And then, in 2016, Macron leaves the government to start his presidential campaign. Alexis Kohler also leaves the finance ministry. And where does he go?
Where?
He moves to Geneva, Switzerland, and takes a highly lucrative position sitting on the board of directors for MSC.
He goes to work directly for his family's multi-billion-dollar shipping empire, the exact same company he had just spent the last 4 years making state policy around.
Yes. He stays on the board of MSC for 9 months. And then, in 2017, when Emmanuel Macron wins the presidency, Kohler quits MSC, moves back to Paris, and becomes the Secretary General of the Élysée, the president's right-hand man.
I mean, you really do not need a law degree to see why Anticor, the anti-corruption NGO, filed a massive criminal complaint about this timeline. He was allegedly utilizing his immense state power to manage policies and contracts regarding a multi-billion-dollar company secretly owned by his family, a company he then went to work for, before returning to the state to wield even more power.
The sheer volume of documentation regarding his involvement in meetings about the shipyards while hiding his family connection led the National Financial Prosecutor's Office to open a probe.
Okay.
And eventually, the investigating magistrates formally indicted Alexis Kohler for prise illégale d'intérêt, the exact same charge of unlawful taking of interest.
I want to be very precise about the terminology here, because legal systems differ. In the United States, an indictment just means a grand jury looked at some prosecutor's evidence and said, sure, there's enough here to have a trial. The standard of proof is relatively low. What does a mise en examen, a formal indictment, actually mean in the French investigative system?
It is a vastly more serious and advanced formal step. In the French inquisitorial system, investigating magistrates gather evidence neutrally. They look for evidence of both guilt and innocence.
Right.
A mise en examen means that these highly specialized judges have reviewed all the financial records, the emails, the testimonies, and they have concluded that there is strong and consistent evidence that the person committed the crime. It is not a preliminary suspicion. It means the judges believe they have the material proof of the offense.
So the president's chief of staff, the man running the daily operations of the country, is formally indicted by financial judges who state they have strong and consistent evidence that he illegally leveraged his government position to benefit his family's corporate empire.
Exactly.
If the bridge of justice applies equally, what happens to him? Does a team of police officers raid his office? Does he get thrown into a 5-square-meter cell in his underwear for 48 hours to prevent him from tampering with evidence or coordinating with his cousins in Geneva?
No. Structurally, politically, and administratively, absolutely nothing happened to him.
Nothing.
Despite the formal legal indictment, the Élysée kept Alexis Kohler in his immensely powerful post. He went right back to his office next to the president.
The presidency released a press statement. I read it. They basically shrugged. They said they had never hidden his family ties, which Anticor hotly disputes, by the way. And Kohler's lawyer issued a statement saying he would prove his innocence in due time. And that was it. He just kept running the country.
It perfectly illustrates the structural impunity at the top. I mean, the presumption of innocence is a fundamental right, absolutely. But when applied to the elite, it is treated as an absolute, impenetrable shield against any professional, administrative, or political consequence.
Right.
Meanwhile, for the public, the presumption of innocence doesn't even save you from being branded in the TIJ database and locked in a cell preventively.
To really drive home this two-tier system, I want to look at a recent event that perfectly contrasts how the French state handles powerful outsiders versus how it handles its own inner circle. Let's look at Pavel Durov, the CEO of Telegram.
Oh, it is a brilliant point of comparison. So Pavel Durov is a Russian-born billionaire, a global tech CEO. In late 2024, his private jet lands at Le Bourget Airport just outside Paris to refuel.
And the French authorities are waiting for him on the tarmac. They arrest him the second he steps off the plane.
They executed a meticulously planned operation. They utilized a relatively new, incredibly aggressive piece of legislation known as the LOPMI cybercrime law. This law is uniquely severe. It allows prosecutors to charge tech executives with complicity in the crimes committed by the users of their platforms.
The state threw the absolute book at him. They didn't just ask him to come in for questioning. They threw him into a cell and held him for the absolute maximum allowable time for organized crime, 96 hours of continuous police custody.
96 hours. They charged him with complicity in allowing illicit transactions, drug trafficking, and child exploitation imagery to circulate on Telegram because he refused to provide encryption keys to law enforcement.
Wow.
When they finally let him out of the cell, the judges demanded a massive €5 million bail, forced him to report to a police station twice a week, and completely banned him from leaving French territory.
Fast, aggressive, uncompromising, physically restrictive justice. When the French state wants to project power, when they want to make an example of an outsider, even a billionaire tech mogul, they deploy the full, terrifying weight of the legal code instantly.
Precisely. The machinery works perfectly when aimed outward or downward. But when the target is inside the walls of the Élysée Palace, when it is the Secretary General himself facing strong and consistent evidence of financial crimes, the gears grind to a halt. The severity just vanishes.
Which naturally leads to the final and perhaps most astonishing question of this entire deep dive. If the president's chief of staff can just brush off an indictment from the financial prosecutors, who actually oversees this two-tier system?
That's the million-dollar question.
Who is in charge of the magistrates, the judges, and the entire architecture of justice? The justice minister. So what happens when the justice minister himself is put in the crosshairs of the law?
To answer that, we have to examine the trial of Éric Dupond-Moretti. And you really cannot understand this trial without understanding the man himself. Before he entered politics, Dupond-Moretti was arguably the most famous, most feared defense lawyer in France.
His nickname in the press was Acquittator, because he was like a Terminator in the courtroom. He had secured over 100 acquittals in major assize court trials. He is a massive, physically imposing guy with a booming voice, highly theatrical, and utterly combative.
He built his career on aggressively attacking prosecutors, finding procedural flaws, and dominating the courtroom. So it was a massive shock to the political establishment when, in 2020, President Macron appointed this combative defense attorney as the keeper of the seals, the Minister of Justice.
Right. He was now the boss of the very prosecutors he had spent decades fighting.
Exactly. But he didn't enter the ministry with a clean slate. He brought massive, highly personal baggage regarding the National Financial Prosecutor's Office, the PNF. To explain this, we have to briefly touch on another scandal involving former President Nicolas Sarkozy.
Okay, the Sarkozy connection.
Yes, the Bismuth affair. Years prior to Dupond-Moretti becoming minister, the PNF was conducting a highly sensitive, top-secret corruption and influence-peddling investigation into Nicolas Sarkozy. During this probe, the prosecutors realized something alarming. Sarkozy knew his phones were being wiretapped. Someone on the inside was leaking information to him.
They had a mole.
Exactly. So to find this mole, the PNF took a drastic investigative step. They ordered the police to pull the phone records, the metadata of dozens of prominent Parisian lawyers and magistrates to see who was communicating with whom.
These records are known in France as fidettes. And I want to clarify how invasive a fidette is. It doesn't give you the audio recording of the phone call, but it gives you a complete map of a person's life.
Oh, yeah.
It shows every number you called, who called you, exactly what time, for how long, and crucially, which cell tower your phone pinged. So it tracks your physical location and your entire social and professional network.
Pulling the fidettes of defense attorneys is highly controversial because it touches on attorney-client privilege. And one of the high-profile lawyers caught up in this massive metadata dragnet was Eric Dupond-Moretti.
And when he found out that the PNF had secretly analyzed his phone records, he went ballistic. He went on television and called it an outrageous invasion of privacy. He compared it to the methods of secret agents and the Stasi.
He was livid.
He was so furious that he actually filed a formal, personal criminal complaint against the specific PNF magistrates who ordered the search.
That was his stance as a private citizen and a defense attorney. But then, a month later, Macron appoints him Minister of Justice. As a requirement of taking office, Dupond-Moretti officially withdraws his personal criminal complaint against the magistrates.
Because you can't exactly be the justice minister suing your own prosecutors.
Yeah.
But he didn't forget.
He did not. Because while he withdrew the criminal complaint as Minister of Justice, he now wielded immense administrative and disciplinary power. And almost immediately upon taking office, he utilized that power.
What did he do?
He ordered formal administrative investigations into the exact same 3 PNF magistrates who had investigated him and his friends.
He literally unleashed the Inspector General of Justice on the people who had dared to look at his phone records. Let's explain what the Inspector General is, because that sounds terrifying for a civil servant.
The Inspector General of Justice is the Internal Affairs Division, but with immense power. They can seize computers, interrogate staff, and build dossiers that can destroy a magistrate's career, strip them of their pension, or result in termination.
Wow.
By ordering this investigation, Dupond-Moretti was explicitly threatening the professional survival of the people who had crossed him.
And this act triggered an absolute earthquake in the French legal system. The magistrate unions, who already distrusted him, went to war. 2 massive unions, along with the anti-corruption group Anticorps, filed formal complaints against the sitting justice minister.
Yep.
The accusation was simple and devastating. He was using his sweeping ministerial powers to settle personal scores from his time as a lawyer.
Which led to a truly unprecedented event in modern French history. The first sitting French justice minister put on trial for conflict of interest while still aggressively holding on to his office.
It was dubbed the trial of the century by the press. But this is where the architecture of the legal system really shows its true colors and where the bridge analogy completely breaks down. Because Eric Dupond-Moretti, despite facing a criminal charge that carries a potential sentence of 5 years in prison, was not tried in a normal criminal court.
No, he wasn't. He was tried by the Cour de Justice de la République, the CJR.
Let's dissect the CJR, because this is not a jury of everyday citizens pulled from the voter rolls.
Not at all. The CJR is a highly specialized, exceptional court created in 1993. It was actually created in the wake of the contaminated blood scandal, specifically to judge government ministers for alleged offenses committed during the exercise of their official duties.
Okay.
But its composition is deeply structurally controversial. The judging body is made up of 15 people. Only 3 of them are professional magistrates from the highest court in France.
And the other 12?
The other 12 are active politicians. 6 members elected from the National Assembly, the lower house of Parliament, and 6 members elected from the Senate.
Wait, so an immensely powerful politician is put on trial for abusing his office, and 80% of the jury deciding his fate are his fellow politicians, people he negotiates with in the halls of Parliament every single day.
It is quite literally a jury of his political peers. And the trial itself was incredible to witness because the evidence presented was overwhelming. The prosecution's case was airtight.
It was.
Yes, even the Inspector General of Justice's own internal report was devastating. It stated explicitly that Dupont-Moretti, as the natural recipient of disciplinary reports and the only authority capable of acting on them, was in a clear, documented situation of conflict of interest.
I read that even his predecessor, the former Justice Minister Nicole Belloubet, was called to testify. And she openly admitted under oath about the glaring irregularity of the situation.
The facts were not really in dispute. And so we arrive at the verdict. The CJR issues its ruling. And the way they structured this ruling is a masterpiece of legal contortion.
Okay, lay it on me.
First, they concluded, as a matter of documented fact, that Eric Dupont-Moretti was in an objective situation of conflict of interest.
Okay.
Second, they concluded that the material acts of the crime, the physical signing of the orders and initiating the investigations into those specific magistrates, were present and proven beyond a doubt.
Right. So, to translate that, they proved he did the action, and they proved the action constituted an illegal conflict of interest. He is guilty of the material facts of the crime.
But the court acquitted him.
I remember reading this headline and having to read it 3 times. How do you admit the material facts of a crime are proven that the conflict of interest existed, but acquit the defendant? What was the mechanism they used to let him walk?
The CJR utilized a highly subjective, nearly invisible legal loophole known as intention coupable, or subjective intent.
Subjective intent.
Yes. The politicians on the jury claimed that while the objective facts of the crime were entirely present, there was no proof of Dupont-Moretti's subjective intent to commit a crime.
I need to understand how his defense lawyers argued this. Because if I unleash internal affairs on the guy who investigated me, the intent seems pretty obvious.
His defense argued that he was merely following the bureaucratic advice of his staff. They argued he didn't read the files closely enough, that he was simply continuing administrative processes initiated before him, and that he didn't realize he was executing personal revenge.
Oh, come on.
And the 12 politicians on the CJR accepted this. They ruled that there was no hard evidence he intentionally, maliciously meant to misuse his position. They essentially said, yes, he committed the illegal act, but he didn't mean to be vindictive about it, so he is innocent.
That is cognitive dissonance elevated to a judicial standard. I mean, think about how that applies to anyone else. If I rob a bank, but I tell the judge, Your Honor, I didn't subjectively intend to permanently deprive the bank of its capital. I just really wanted to hold some cash to feel secure for a few days. I was following the advice of my financial anxiety. I'm still going to prison.
Yeah, you are.
The material act of robbing the bank is the crime.
Exactly, and it does not hold up in the eyes of the broader judicial community. The reaction to this acquittal was swift, brutal, and profoundly cynical. The lawyer representing the magistrates' unions called it imperfect justice.
I bet.
They pointed out the hypocrisy of a system that demands absolute accountability from citizens but accepts, I didn't mean to, from the highest legal officer in the land.
Anti-Corps was even harsher, weren't they? They pointed directly at the structural flaw of the CJR.
Yes. Anti-Corps released a statement pointing to the fact that the CJR is a special court for politicians, judged by politicians. They stated, quote, "Justice for ministers is unfortunately a political justice, in clear violation of the principle of equality before the law."
It's hard to argue with that.
Even several opposition parliamentary groups publicly called for the CJR to be dissolved entirely, stating it was systematically partial and existed only to protect the elite caste.
It is the ultimate crowning accountability gap. We have a system where the elites are judged by a jury of their political colleagues who can magically deploy invisible subjective loopholes about intent to excuse hard material facts.
That's incredible.
And meanwhile, right after the acquittal, the Prime Minister at the time, Elizabeth Bourne, tweets that she is delighted by the verdict and that it's a victory for the government, keeping him in his post without a moment of hesitation.
And that tweet, that celebration of impunity, perfectly encapsulates the architecture of the system we are examining today. When you step back and connect all these individual pieces, the finance, the policing, the courts, a very clear, very disturbing picture of modern statecraft emerges.
Let's synthesize this journey because the paper trail we follow today is extraordinary. We started in the closed-door meetings of the Elysee, examining the opaque sell-off of Alstom's nuclear and military turbine division to the Americans.
Yeah.
A deal orchestrated by Emmanuel Macron that generated 265 million euros in fees for intermediaries like Rothschild, which then mysteriously circled back to fund the massive political ambitions of the man who signed the authorization.
We then looked at how that resulting executive power maintains its grip when the public suffers the economic consequences of those policies. We saw the Élysée bypass meritocracy to install a loyalist prosecutor, Remy Heitz. And we saw Heitz issue written directives perverting the legal code, weaponizing police custody into an administrative tool, locking innocent students, scientists, and volunteers in freezing, feces-stained 5-square-meter cells for 48 hours purely to prevent them from participating in democratic protest.
And finally, we looked at the impenetrable, custom-built shields protecting the inner circle. Alexis Kohler, the shadow president, indicted by specialized magistrates with strong and consistent evidence of massive financial conflicts of interest involving his family's shipping empire, yet keeping his job and his power without a single hiccup.
Unbelievable.
And the justice minister himself, Eric Dupond-Moretti, put on trial, proven to have committed the material acts of abusing his office for revenge, but acquitted by a court of his political peers because they looked into his soul and decided he lacked subjective intent.
Maintaining strict objectivity and looking only at the documented facts reveals a stark reality. When the architecture of justice allows the executive branch to select prosecutors who throw citizens into preventive detention on a whim, while simultaneously relying on special political courts to acquit ministers despite overwhelming material evidence, the very concept of the rule of law fractures.
It really does.
It splinters into two completely separate realities operating in the same country.
It leaves you with a profound question about the nature of our institutions. If the very bodies designed to hold power accountable, like the highest prosecution offices or the special courts for ministers, are ultimately staffed, funded, and judged by the political elite themselves, is the system actually broken? Or is it functioning exactly perfectly as it was designed to?
That is the crucial question, and it's a question that goes far beyond France. It's a question about the nature of modern democratic institutions everywhere and who they are truly built to serve.
It really makes you look at that bridge we talked about at the beginning. If the laws of physics only apply to the people walking on the crowded, freezing lower deck, while the politicians and bankers in the luxury SUVs on the upper deck get to float effortlessly above the concrete, maybe it's time we start demanding to see the blueprints. Thank you for joining us on this deep dive. Keep questioning the structures of power around you, keep looking for the mechanisms behind the headlines, and we'll see you next time.